So thank you for inviting me to your city and your university. This is my first time in Montreal, if you don't count the airport. So it's a bit windy. Is it always this windy? No? Oh, good. Do the front lights, we need the front lights on? I'm wondering whether these lights can go off over the...
Maybe lower the intensity or...
The ones that are right on the display.
Just, beside the screen. That's it.
There,
Okay, that's
good, good. Because we're going to be looking at texts. So we need to be able to see things. And people in the back, if you at some point want to move forward, feel free to do so. Challenges for automated semantic analysis of legal texts. And I am the director of the research laboratory for Law, Logic, and Technology at the Maurice A. Dean School of Law at Hofstra University in New York, just east of Manhattan. You can see our website, lltlab.org, and see a lot of the information I'm going to be talking about, or at least the way we think about it. So what do we do? Before I jump into my topic, I want to tell you about the research lab, the LLT lab, Law, Logic, and Technology, because I'm taking this opportunity to talk about one aspect of what we do. So really it divides, in my mind, into two parts. The lab products, the things we do individual as the lab, and then the applications. These things, for example, we figure out how to make legal knowledge operational. And I don't want to say just computational, but operational for humans as well as machines. And figure out how to make it work in a way that it is both computable and humans also find it useful to organize knowledge this way. We're also going to be talking about the other thing that we make, protocols. And I'll talk about that in more detail in a few slides. When it comes to, so we make operational legal knowledge and we make the protocols for how to make the knowledge. And then that is used in our collaborations with, for example, Carnegie Mellon University, the computer science, the language technology people at Carnegie Mellon, University of Pittsburgh, Cornell, online education applications with MIT Digital Humanities, and other units at Hofstra, automating document assembly. All of these applications come from having the legal knowledge operational and the knowledge for how to do it, the protocols. When you look at our website, you'll see we have three major research areas. The latest over the last year and a half is with veterans claims in the United States. But it's a typical kind of project in that we have a project, our other projects are on vaccine compensation, on medical malpractice cases. But I'll be talking a lot today about the veterans claims for disability. And these two things on the right, in the middle, we make a corpus of annotated semantic data for machine learning or for programming, but also it is part of our understanding of how a lawyer thinks. And then we pull out reasoning patterns that we see in the cases, and there again, that provides templates or types for the automation side, but also helps organize human thinking about types of reasoning that we see in these cases. I want to say one thing very briefly about what I mean by semantic annotation so that all of us here from whatever background understand what I'm talking about. And this is really behind everything I'm going to say for the next 50 minutes. Semantic annotation. Markup languages, HTML or XML, are used to insert code in text files for either formatting or interpreting spans of text. An insertion can be manual by humans or automatic by software. So for example, an example of semantic annotation in text, here we don't need to read them, we have 3 sentences in a text file to insert codes around that middle sentence. The start tag, it's a finding sentence. We'll talk more about what that means. Therefore, the board finds that the alleged in-service stressor actually occurred and resulted in the veteran's current post-traumatic stress disorder. End of finding sentence. So when I talk about annotating texts, manually or through automatic processes, I'm talking about inserting those codes. They don't always have to be embedded in the text. It's easier to see, and this is typical HTML, XML embedded code for those of you, familiar with it. It could be not inserted in the text, but rather a list on the side that says from character such and such to character such and such, that's a finding sentence. So the annotation could be offset with pointers into the text, or it can be actually embedded in the text. Either way, it's annotation of the text. And when we talk about semantic annotations, we are annotating them for meaning, for what human beings think it means. So we'll see lots of examples. So the outline today, 2 parts. Challenges to automatically annotating and monitoring systems of legal rules. And secondly, challenges to automatically annotating and analyzing patterns of argument or reasoning in adjudicatory decisions about fact-finding. That's like the veteran's claims that my PTSD was due to something traumatic that happened in service. So think about this as 2 big sets of problems. How to annotate texts for legal rules and what a lawyer wants that to do to be operational. And then going to these fact-finding decisions and seeing patterns of reasoning in the fact-finding decisions. So we're going to talk about that one for the next 25 minutes or so. Main sources of legal rules, there are quite a few. I'm talking about US law, but the main ones, statutory texts as enacted and as codified, regulations issued to interpret and implement the statutory provisions, and appellate judicial decisions that interpret statutes and regulations and apply them to individual cases. We're going to have examples of all of these. So my first set of examples are going to be from the statute that we call EMTALA, Emergency Medical Treatment and Active Labor Act. This is the statute that governs the requirements of hospitals when someone goes to the emergency room, the emergency department in the United States. The policy behind EMTALA going back to the mid-'80s, when a serious problem was dumping patients or transferring patients if they couldn't pay. So they would arrive at the emergency room. They would not have insurance. There's no reason to think they can pay for the treatment, and so you either discharge them immediately or you transfer them to another hospital, so-called dumping of patients. It was made illegal by EMTALA. The policy behind it to prohibit hospital emergency departments from dumping or transferring uninsured or indigent persons. basic requirements of EMTALA. When a person comes to the emergency department of a covered hospital, EMTALA requires, under certain conditions, that the hospital provides an appropriate medical screening examination, the quotes are from the statute, to determine if an emergency medical condition exists. So they have to provide an examination. And if one exists, they find the emergency medical condition, then provide treatment necessary to stabilize it before they can discharge or transfer the patient. So that's the basic requirements. And we're not going to be talking about the ins and outs of EMTALA. It's a very complicated area of law. We're using it as an example for how to do semantic annotation that would monitor the legal rules of EMTALA as they evolve. Okay? So it's just an example for our purposes. It could be any statute. What makes it interesting from my standpoint in terms of legal research, these requirements, screening and treatment, are enforceable by private lawsuit for damages for personal harm directly resulting from a violation. And so we get damage actions around the United States for violations of EMTALA. So here's one of the key texts of EMTALA. In the case of a hospital, so this is text from the statute. In the case of a hospital that has a hospital emergency department, if any individual, whether or not eligible for benefits under this subchapter of the code, comes to the emergency department and a request is made on the individual's behalf for examination or treatment for a medical condition, the hospital must provide for an appropriate medical screening examination within the capability of the hospital's emergency department, ellipsis, to determine, the ellipsis is not in the statute, there are more phrases in there, to determine whether or not an emergency medical condition exists. Remember, I'm using this as an example of a text that needs annotation and the problems with either human annotation or software annotation, automatic annotation. One thing is these sentences. Actually, this sentence for a statute in the United States is relatively short and uncomplicated. The statutory sentences are very long, could be hundreds of words, and very complex with lots of dependent clauses, so on and so on. One thing, so how does a human being deal with this? Well, one thing is to break out the logical connectives and figure out what the pieces are of this. So we have words like if and or and and or are straightforward logical connectives that can tell us how to parse this provision. But then we get these other words that do a similar thing. In the case of a hospital that has a hospital emergency department, whether or not eligible for benefits, referring to the individual. That comma there after for a medical condition, logically, it would have been nicer to see the word then as the connective. Then this. But we don't. We don't. This is the statute as they wrote it. What else do we want to see in this when we see the pieces? We analyze it for its semantic content. One thing is we're looking for legal rules are conditionals. If something, 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 then something. Very often, then you do, then you shall do, then you report, whatever. In this case, so I've highlighted in green what I think the conditional content is. So part of it is, now we're going to try to dig out the conditions that trigger the conclusion. We need to find the conditions and the conclusion. Now, the logical connectives help us divide it into pieces, but still the piece of the word spans that we get after we do that are not nice, right, from a standpoint of forming sentences. In the case of a hospital that has a hospital emergency department, if any individual comes to the emergency department, we'll just ignore the paren for a minute, and a request is made for examination or a request is made for treatment. So we have to read that or as involving two propositions, comma, then conclusion. The hospital must provide for an appropriate medical screening examination and so forth. It's what a lawyer sees. Conditions, triggering, obligation. We can picture it this way. We can rearrange it. We can pull out the propositional content. We can make the logical connectives explicit. And we have a pretty straightforward representation of the legal rule. If something is a hospital, because it only applies to hospitals, doesn't apply to me or the doctor. This rule doesn't, right? It only applies to hospitals. And if that hospital has a hospital emergency department, not all do, but if it has one, and if any individual comes to the emergency department, and if a request is made on the individual's behalf for examination or treatment for a medical condition, then the hospital must provide for an appropriate medical screening examination under EMTALA. If it doesn't, it violates its screening obligation under EMTALA, which was triggered when the four conditions, the four if propositions were satisfied, right? Were true. In the lab, we tend to turn this around and put the conclusion first. A hospital must provide for an appropriate medical screening examination under EMTALA. That is true if the following four things are true. So it's the same thing reorganized. But you can see it as a data structure that goes with propositions, the proposition at the top. We're always asking, under what conditions is that true? And it's the rules that tell us that. So there are four ands. It's a conjunction. There are four of them. They're the same conditions that we saw on the earlier slide. If you prove the four, then you prove the conclusion. It's the legal rule that tells you that. That you cite EMTALA for that proposition, authority, right? This is what we call a rule tree. You'll see why a tree in a minute, but these are inference structures. And so, or if you think of it as a data structure, then the head entry is the proposition, and under it are the conditions under which it is true as a matter of law, as a matter of legal rule. So another way to think about this is it's setting the semantics, right? Authoritatively setting the semantics for must provide for an appropriate medical screening examination. When is it true? We're going to be focusing not so much on something as a hospital. I mean, you read enough statutes and you guess, all right, there's probably a definition of a hospital, right? The definition of an emergency department. We're actually going to be thinking about the meaning of comes to, which doesn't look like the big problematic thing that it turns out to be. But before we do that, I want to talk about that other thing that I mentioned that my lab makes, protocols. A protocol is a set of methods, criteria, and conventions for manually annotating text for a specific semantic type. For example, legal rule condition, those green highlighted things, right? The big picture is, at the lab, we make semantic data. We mark up texts so that Carnegie Mellon and Pitt can use it for machine learning or for rule-based programming to make automated annotators. What we're trying to do is build the software that will do the annotation for us. Now, in order for that to happen, we have to tell the software what we're looking for and how to find it. Well, machine learning, how much of it is just in the statistical model, how much can it get for if you, even in that case, especially in that case, you have to mark up a lot of documents for machine learning to start working. But the goal is to create what's called a gold standard for the software side that they can use to train the software, write the programs, decide how well the performance metrics, right? I mean, you have to decide whether or not the software got enough things right or how many things it got right. And by getting right, I'm talking about marking up the right span of text with the right type. But in order to do that, we have to get human beings correctly annotating, consistently, validly annotating the text. Protocols do that. Uses of protocols, training annotators. I have what in our system, so law is a graduate degree, 3-year program, JD program. I have second years and third years in the lab. So every year I bring in 6 or 7 new 2Ls, second years. They have to be trained. The protocols provide the training. Assuring quality and accuracy. Increasing annotation reliability. I mean, we want inter-annotator reliability. We want consistency between annotators. On top of that second bullet, not only are they marking up text the same way, they're marking up correctly, validly, compared to what we think a lawyer would consider a rule condition. So there's a quality assurance function of the protocol. Developing and training software, the automation side, we give what do we give Carnegie Mellon? Well, we can give them 2 things. We can give them the marked up texts, which we do, or we can give them the protocol, which is, picture I should have put an example. A protocol is, if you see this in the sentence, if you see this in the span, and then here we're talking about, let's take the example of finding a sentence that states a rule. There's a list of things, of criteria, that make it more likely to be a rule. Turns out very few of these are mechanical. They're not. If you see this, then let's say, if the sentence is followed by a citation sentence, and the citation sentence is to one of these courts, then the sentence preceding the citation sentence is more likely to be a legal rule. But I can show you examples where that doesn't work. And so on down the line, you go through a list of criteria which, if they're satisfied by the span you're looking at, make it more likely that the span is of a certain type. So for every type, you need protocol to train the human beings, right, the annotations, to make sure they're all doing it correctly. Then you can deliver the product to the engineering side. Another function is building compatible data sets. You need standards, right? So that if you're marking up texts here in Montreal and I'm marking up texts in New York, we're using the codes the same way. Otherwise, we have incompatible data sets. We develop these protocols in stages. We collect a lot of examples. And some of them are what we consider normal forms, and then lots of variants. So a lot of the protocol are examples, prototypes. From those, we get guidelines and criteria for annotation. We develop this list of tests, probabilistic tests. And we can then use that to suggest programming rules for software or developing feature sets for statistical models. So, in my experience, from the law side, because all of this is cyber justice, right? AI and law. From the law side, we're a long way from where we need to be to help the AI side do its job, because they don't know what they're looking for. They don't know how to mark up the text. It takes that kind of collaboration. And I think that's one of the main things holding back development in this field, is the law content side about the not only coding things, because you hear lots of complaints, you know, we don't have enough coded texts. But if we're just handing them garbage, inconsistently coded, inaccurately coded, we're not doing anybody any favors, and we're never going to get to where we need to go. Okay? But statutes are only the beginning. Where do we get legal rules? They also come from the regulations issued under the statutes. So here's a regulation under EMTALA, codified in the Code of Federal Regulations. And it defines comes to the emergency room. Comes to the emergency department means, with respect to an individual who is not a patient, as defined in this section, the individual, and I've left out a lot of things, these 4 provisions, just to highlight the parts where they're somewhat different. The individual has presented at a hospital's dedicated emergency department. They actually showed up at the emergency department. That's the clearest case, right? Then they've come to the emergency department. But what if there has presented on hospital property other than the emergency department? They go to the wrong door. Have they come to the hospital for purposes of EMTALA, come to the emergency department for purposes of EMTALA, with the triggering of the screening requirement? Or 3, notice we've got an or down there, 1, 2, 3, or 4. Any of these counts as coming to the emergency department. They're in a ground or air ambulance owned and operated by the hospital. They're on their way to the hospital in the ambulance. Well, that counts as coming to under this regulation. Or 4, they're in a ground or air non-hospital owned ambulance, but they're on hospital property. Regulation says they've come to the emergency room. They're not in a hospital-owned ambulance, but they're in an ambulance, and they're on hospital property. That counts as coming to, triggering the requirement. The or is easy to pick out. We have a list here of 4 conditions, but notice this. With respect to an individual who is not a patient, this regulation only applies to non-patients. And that is a condition for this rule. You see the rule, right? What does the rule of the regulation look like? A hospital must provide for, so let's put it in the bigger context. This is the statutory rule, right? When do you have to provide for an appropriate medical screening examination? It's a hospital, so on and so on, and comes to. Well, we're expanding that branch of the tree. What counts as coming to the emergency department? How do you prove that the individual came to the emergency department? What do we mean by coming to an emergency department? All those variations come down to the same thing. What's the rule for proving it? Let's move that to the top, and 3 of 4 from that earlier list, right? Any individual comes to the emergency department. Well, 2 conditions have to be satisfied. One, under this rule, right? There might be another rule for patients. We're just talking about non-patients. This is a rule about non-patients. One condition is not a patient of the hospital. And at least one of 4 conditions is met, the 4 that we looked at. So you see why we call this a rule tree, because the branches keep expanding into new rule conditions for proving the one before. It expands into levels without cycling back. So it's a tree structure. And our methodology is that every set of legal rules, you pick the thing you're trying to prove at the top, and what will come under it is a tree structure telling you all of the conditions in various levels for proving what you're trying to prove. At some point, the rules stop, and we have terminal rule conditions. Are you with me? No more rules. It's just a condition you either have to you have to prove or you fail. That's where the fact-finding takes over. How do you prove it when there aren't any rules? But here we still have rules, and we've got actually more rules to go because we've only done statutes and regulations. Look at that last one. The individual is in a ground or air non-hospital owned ambulance on hospital property. Regulation says that counts as coming to. But then it also said this in that section of the CFR, of the code. It added 2 more sentences, the agency that issued the regulation. However, an individual in a non-hospital owned ambulance off hospital property is not considered to have come to the hospital's emergency department, even if a member of the ambulance staff contacts the hospital by telephone or telemetry communications and informs the hospital that they want to transport the individual to the hospital for examination and treatment. They haven't come to the hospital emergency department yet. But then they wrote another sentence. And regulations in the U.S. are law, have the full force of law. They're equal in force of law to the statute. So these are binding on covered parties, right? The hospital may direct the ambulance to another facility if it is in diversionary status. That is, it does not have the staff or facilities to accept any additional emergency patients. Now, I've highlighted this because when you read the first of these 2 sentences, if an individual is in a non-hospital owned ambulance, then not considered to have come. But then you read the next sentence and it seems to have another rule, right? If it is in diversionary status, so defined, then the hospital may direct the ambulance to another facility, not violating EMTALA. So, of course, you know there's going to be a case. Morales v. Sociedad Española, so on and so on. First Circuit, 2008, cert denied, Supreme Court. So the Circuit Court, here were the following facts were either undisputed or must be accepted as true for purposes of deciding there was a motion for summary judgment before the court. Quote, a bunch of things from the case. The ambulance, the one transporting the plaintiff, was not owned by the hospital, and the paramedics who manned it were not hospital employees. So it's not hospital owned. The paramedics opted to take the plaintiff to the hospital. They decided to go to the hospital. What had happened, the plaintiff's obstetrician had diagnosed her as having a non-viable ectopic pregnancy, and she was experiencing severe abdominal pain. So what do? They contacted the hospital's emergency department while en route and made this intention known. We're bringing her in. Get ready, right? You got a serious case here. They requested the hospital to admit the plaintiff for a screening examination in order to assess and, if necessary, stabilize and treat her condition. Instead, and this is on motion for summary judgment, and these are jury cases, so the court said, it is reasonable, though not inevitable inference for the jury, that the hospital, after learning about the plaintiff's uninsured status, signaled the paramedics to transport her elsewhere. So the case clearly is about, had she come to the emergency department yet? The First Circuit said, simply put, without some language qualifying the relationship between the second and third sentences, and I'll show them to you again, but it has to do with those two sentences they added on. It is unclear whether a hospital may divert an approaching ambulance only when it is in diversionary status, or whether it may do so under other circumstances. Now, so the First Circuit is thinking about another rule. We are left to wonder whether, if an individual in a non-hospital-owned ambulance has not yet reached the hospital property, under that condition, a hospital may redirect the individual for virtually any reason, including impecuniousness, no money. So the case, they thought, had to do with these second and third sentences. So look at them again. An individual in a non-hospital-owned ambulance off hospital property is not considered to have come to the hospital's emergency department. Full stop. If they had not written the third sentence, I think it would be pretty clear. You're in a non-hospital-owned ambulance and you're not on the property. But they wrote a third sentence. The hospital may direct the ambulance to another facility if it is in diversionary status. What about if it's not? Can they divert it because she doesn't have insurance without violating EMTALA? First Circuit decided she had come to the hospital. They couldn't divert her for lack of money. It would violate the policy behind EMTALA. An interpretation of the statute concluding that an individual en route to the hospital under the plaintiff's version of the facts has come to the emergency department fits most squarely with the statutory intent of preventing hospitals from dumping patients. Now, how do we represent this as a rule? There's a couple of things, right? You saw those sentences we were looking at. How do we spot the conditions and the conclusion of the rule they're even thinking about? To extract it. Once we extract it, how does it relate to the rule tree? I think that it's really a situation number 5. It's the case of Morales, where you're in a through 4 was you're in a non-hospital owned ambulance and not on the property. Morales is creating either an exception to that, or it's adding a number 5, one way or the other. But it is a rule from the case. And the rule from the case is, under the plainest version of the facts. Now that's another tricky aspect. This is a sentence from the case, right? You have to go back and dig out the relevant facts as the conditions for the new rule. Somehow humans have to do that. Lawyers do that when they figure out what is the rule of Morales. Can I argue the rule of Morales in my case? Well, is my case like their case? Well, which are the relevant pieces of, facts from their case to line up with mine? Or is it distinguishable? But also, lining up the conditions for the Morales rule is something that humans have a problem with, and the notion that software is going to do it also is a reach. And yet, if we want software that monitors statutes, regulations, and interpreting case law so that we get a representation of the evolving rule system that governs cases to be decided, and we want software to help us do that, how much of that can software do? That's a challenge. So what kind of challenges from statutes, regulations, and case law when we're extracting rule systems? We have long, complex sentences, that's for sure, in statutes and regulations. We have insufficient linguistic cues for the logical connectives that connect the pieces of those sentences. Difficulty extracting the content of rule conditions and conclusions from those sentences, although I dare say it's easier to do from the sentences in the statute and regulation than it is from the case. Inadequate explicit definitions. We have, if you have a definition of a hospital or an emergency department, but here we had the word comes to, perhaps any word in a statute or regulation can have an open texture when we stare at it long enough and come up with a problematic case. But if we don't capture the case law interpretations, then we haven't captured or represented the entire system of rules. Any lawyer who overlooked Morales as a possible argument would have serious problems in terms of representing the client. Integrating a complete system of legal rules from statutes, including amendments over time, regulations, and appellate case law. Yeah, picture this. At any one point in time, there is a rule tree for EMTALA obligations. But the rule tree changes diachronically over time because of case law, because of regulations, because of amendment to the statute. Identifying and semantically analyzing the sentences in judicial decisions of state legal rules and integrating those rules into the rule tree. All challenges, if that's what we want to do, represent the evolving, or at any one time, the governing system of legal rules from the documents we have to work with. Okay, let's switch to the other side. Challenges to automatically annotating and analyzing patterns of argument or reasoning in adjudicatory decisions about fact-finding. When the case starts, or at the point of decision in the case, there's a rule tree that governs the rules on how to prove things as a matter of law. But as I said, all those rules stop in conditions, And there's going to be lots of words in those conditions that we don't know how to interpret them. But if we want to monitor the fact-finding. So let's switch to veterans' disability benefits in the U.S. And this is pretty much all you need to know about that for our examples. Under certain conditions, a veteran may be eligible for compensation for a disability that is service-connected. So you have to prove that it's service-connected. Proving service connection, if the veteran proves the existence of a present disability, an in-service incurrence or aggravation, statutory language, of a disease or injury. In the case of PTSD, post-traumatic stress disorder, you're looking for an in-service stressor. Maybe you didn't have diagnosed PTSD while in service, but you have to prove that in service there was a traumatic event. And third, a causal relationship or nexus between the present disability, let's say the PTSD, and the disease or injury incurred or aggravated during service, and in the case of PTSD, the in-service stressors. So you have to prove the causal link. So there's three conditions for proving service connection. Now, picture a rule tree, right? Just like the one we've been talking about for EMTALA. Three conditions, conjunctive. If you prove them, you prove service connection. And if you satisfy these requirements, entitled to benefits, depending on the severity of the disability. Okay. Who are the actors in, this is a very complex system, the VA system in the US for disability claims. Congress wrote statutes and amends them from time to time. The Department of Veterans Affairs issues regulations. There's adjudicatory decisions. In fact, there's quite a few. There's a Board of Veterans Appeals that's an administrative tribunal within the Department of Veterans Affairs. And it hears appeals from the regional cases. But it decides it is a fact finder, you'll see. You can appeal from that to the Court of Appeals for veterans claims. You can appeal to the Court of Appeals for the Federal Circuit. And conceivably, you can appeal or cert to the Supreme Court. Now, statutes, regulations, and the appellate court cases are where we get the legal rules. That's what we've just been talking about. So the software that's monitoring the state of legal rules for the VA cases has all of these kinds of documents as input. The Board of Veterans Appeals is the fact-finding body from which we get nice decisions. Nice as in texts. Lots of texts, lots of decisions. As of September 2017, Carnegie Mellon had pulled out, we're approaching 1 million decisions from the BVA, the Board of Veterans Appeals, the fact-finding body. From 1992 to 2017. In fiscal year 2015, for example, there were over 55,000 decisions. 98% of those involve claims for disability compensation. So if you just talk averages, they're out there cranking out, publishing to their website, 1,000 decisions a week. They run anywhere from 100 sentences to 1,000 sentences that we've seen. So even if we call it 150, they're generating 150,000 sentences a week. From which what? We're trying to extract patterns of what kinds of arguments, evidence-based arguments, win and lose, successful, unsuccessful. So we need automation. If you are, Carnegie Mellon has approaching 1 million plain text documents. from the department website. If you want to find something in there, you need to, if you're looking for some kind of decisions, you need some search algorithm for finding it. And what we're shooting for, you'll see in a minute, is not just the kind of Google or Westlaw kind of, or Lexis kind of list that says, well, you have 10,072 hits. Read these. Large data sets and answer to queries about argumentation reasoning. Why else might we want to do this? To monitor consistency among large numbers of decisions on same sub-issues. I dare say nobody knows what the BVA is doing under those three prongs of proof for service connection. Because who's going to read? Nobody's reading these cases. I mean, the parties are, but who's deciding whether the reasoning is consistent? Or trends over time, if there are trends over time. Predicting outcomes based on available evidence. So I have a new case and I have this kind of evidence, and I think proving the causal link between this thing that happened in the service and my current PTSD is my weakest part of the argument. So what kinds of arguments have won and what kinds of evidence have won and lost? And of course, improve efficiency of claims proceedings. Because if we know early on that with your kind of situation, you have a fairly weak case on the evidence you have, maybe you should go get corroborating evidence from some of your buddies in service, if it's the in-service stressor that's the problem, and so on. Improve your case. This is squarely cyber justice, I take it. The automation to increase the access to justice in an area where it's not humanly possible to even scratch the surface. Just to show you, Westlaw, Lexis, you can get these decisions, BVA decision 13.16.336, one of in our sample that we annotate. You can get these on Lexis and Westlaw, but all you get is plain text. You don't get any head notes, right? We're talking 1,000 a week. So you can get them there. Lexis Advanced does this. I don't know what they're doing with core terms. I think that's just a term frequency, kind of a word cloud panel. And lo and behold, veteran. That's not going to be very helpful in terms of distinguishing these cases. What do we really want? We want to reach inside the decisions. We want to take those texts of statutes, regulations, and appellate decisions and make this integrated rule tree of what the sub-issues are. And this is an area, too, I'm not even suggesting, I mean, this in the examples, there are statutory presumptions, there are regulatory presumptions, there's all kinds of presumptions of proof in this area. So the rules are complicated. Here's what practitioners see after they find it. Here's what they want to see after the software finds it for them. What do they want to see? They want to see something that codes, you don't need to read this at all, just look at the colors, that highlights, codes, encodes, annotates the finding sentences. So you can look through and see, well, what were the findings on the main rule conditions? But more than that, the evidence sentences, because I want to know what kind of evidence they had in this case. And reasoning sentences that connect the evidence to the finding, that explain their thinking. So there's a lot to be mined here. But there's a problem. Unlike statutes and regulations, in statutes and regulations, almost every sentence states a legal rule. But that's not true in judicial decisions. in adjudicatory decisions. There are sentences of state legal rules. There are sentences that state legal policies and principles, and they cite to authority. Just think of any, fact-finding trial court level decision that you work with. There's other sentences that tell you about the procedural history in the case, motions by attorneys, arguments on the motions, rulings on the motions. And then there are other sentences that tell you about the evidence they had, the arguments, the findings, and the reasoning. But those are sentence types. And this typology we use for sentence types in the lab, sentence level, sentence role in inference. So everything from citation sentences down through procedural fact sentences, the kinds of things I just went through. But here we have 10 sentence types. Let's take the example of the words, the veteran has a present disability. That might occur in a procedural fact sentence. The veteran alleges that the veteran has a present disability. The attorney for the veteran argues that, right? It's just what's happened in the case. It could be a legal rule sentence. One of the things you have to prove is that the veteran has a present disability. It could be an evidence sentence. The medical record or the expert testified that the veteran has a present disability. It could be a finding of the BVA, which is one thing you really want to know. They found that the veteran has a present disability. It could occur in their sentences where they reason through the evidence, but they haven't quite reached their finding yet. It could even happen in some of these other things, ruling or holding, ruling as a matter of law, rule-based reasoning, citation sentence. Oh yeah, you can have a sentence with a citation, you know those ugly things in US law, I hope you don't do that. Parentheticals, right? Inside the parenthetical, you could easily find that text. But we especially want to find the sentences that tell us the findings of fact, not just on the overall case, but on these key issues, like the 3 prongs that you have to prove: present disability, in-service stressor or incurrence, and the causal link. Why? Because you can find a winning argument on prong 1, condition 1, in a case where they lose, because they lose on prong 3. But if you're looking for winning arguments on prong 1, that case is as good as any other. They don't have to win the case. They just have to win the issue. We're interested in what kind of evidence won or lost. We're interested in what kind of reasoning connected the evidence to the finding. This is what we mean by patterns of fact-finding, argument, and reasoning. You have to find those in the cases, in the decisions, in the plain text files. Let's take one example, the phrase credible evidence. Now this comes from a regulation. Service connection for post-traumatic, this is the Code of Federal Regulations, service connection for post-traumatic stress disorder, PTSD, requires medical evidence diagnosing the condition in accordance with this chapter. So it has to be diagnosed with standard psychological, psychiatric criteria. A link established by medical evidence between current symptoms and an in-service stressor, and credible supporting evidence that the claimed in-service stressor occurred. So now we're wondering, well, what counts as credible supporting evidence, which is one of the things required in a PTSD claim? Well, when we look through, so that's the regulation. When we look through BVA cases, to see how the words are used. A credible witness is one whose statements are within reason and believable. Credible testimony is that which is plausible or capable of being believed. There's simply no competent and credible evidence, and I put competent in red there because that's, for them, a different concept. The veteran is competent to testify about her symptoms, but she is not competent to testify as to a diagnosis because she doesn't have the expertise. That's competence. The weight, probative value, and those seem to be interchangeable. The weight of the weight of the testimony, the probative value of the testimony, and the credibility of the evidence. And that's also distinct from our notion in the states of sufficient evidence, which is an issue of law, whether you have sufficient evidence, whether a reasonable fact finder could or is allowed to find given so little evidence. We also find that the board, language like the board finds that the veteran lay testimony is supported by credible evidence. Sounds like a reasoning, a conclusion of the board. But it might also be at least one of the veterans treatment providers, Dr. H.B., has found him credible in his account. So we have to tell those sentences apart. We're looking for the board's reasoning and not Dr. H.B.'s. So let me just quickly look at this. 3 reasoning sentences from this case. Upon review of the evidence of record, the board finds the veteran's statements are not credible as they are inconsistent with and outweighed by other lay and medical evidence of record. Credibility can be generally evaluated by a showing of interest, bias, or inconsistent statements, and the demeanor of the witness, facial plausibility of the testimony, and the consistency of the witness testimony are, and they're talking about consistency over time. Story changed over the years, are also factors that may be considered. The board emphasizes that the court has recognized that personal interest to receive benefits may affect the credibility of the testimony, of the evidence. Now, there's a lot to be mined in this about the meaning of credibility or how you prove that testimony is credible. For one thing, we've got in the first and explicitly in the first and last sentence, the board, this is the board's thinking. This isn't the testimony of a witness or an argument of an attorney. They're contrasting evidence. They're comparing evidence. They're comparing the veteran statements with other lay and medical evidence and deciding whether they're consistent or not, or probative value, one is outweighed by the other. How do you decide this weighting business? Well, they talk about factors. What factors can you consider in deciding whether testimony is credible? Interest, bias, inconsistent statements, demeanor, so on. All of that information tells us what credible evidence means for purposes of that condition of service connectedness. In the fact-finding tribunal, they don't make rules. They only call facts, right? But they give reasons. And there's a lot of information in the reasons that they give. Automatically extracting patterns. All right, what are our challenges? We're getting really to the end here. What are our challenges when we try to monitor and mine these fact-finding decisions? So you've seen lots of them. There's many inferential roles for sentences. We have to start parsing our sentences. And logical connectives are not as clean as they are in the staff that, I mean, as bad as they are there. In the staff that write the statute, they're relatively regular. We've got just judges individually writing sentences. Difficulty extracting the content. We're trying to put together patterns. word usage in adjudicatory decisions not as regular or careful. There's just a lot of noise in there. And these relevant factors that are probabilistically connected to whether it's credible or not. You know those rules we looked at? They're deductively connected. If this and this and this, then that. Not so much in... those of you familiar with logic, I mean, I taught logic. If you spend your time looking for a modus ponens or some logical deductive structure, hardly ever find them. Concluding remarks. This is my, and I guess maybe this is a bit of the other end from what you heard 2 weeks ago. On representing meaning, because that's what we're doing, right? With the software. I mean, humans are trying to annotate the meaning or the things that are meaningful. And the software we're trying to get to do what the humans do. Well, meaning is a term, and I'm heavily influenced by Wittgenstein's later work. Acceptable usage in a language game. And proving is a language game. Proving to the BVA might be a language game, separate from proving to some other tribunal. Within forms of life. Logic's task is to describe the rules of play, the word usage, the correct usage. That's what lawyers are trying to do. A new argument is supposed to appear to be a winning argument to the hearer in the people trained in the same language game. But there's a vast number of language games within forms of life, Wittgenstein said. Don't think, but look. Just look at word usage. Look how it's used. Core usage within legal rules is supervised by legal authorities who write statutes and regulations and write appellate cases. Binding on participants, the rule tree, and we saw that with comes to the emergency department. But we still know that comes to is open textured. And it isn't as though we can anticipate what the next case is going to look like. I read today, the baby born in the emergency room. Has the baby come to the emergency room? And requested, right? Core usage within evidence assessment, patterns of successful argument, usage for credible testimony. We just have to assemble the stuff. Don't think too hard about it. Just look and see what it means, how it works. So how to represent law as computable language. With a vast amount of usage data and yet to some extent rule governed, highly rule governed, right? And systematic in a dynamic sense. And back in my early days, I was influenced by the logicians who see deductive systems. Now what do I see? I think that's what the law looks like. It's a galaxy of star systems rather than an axiomatic system. If we want to map it, we have to figure out how to map that. But that's the task. Thank you.